Assalamu alaikum. It's absolutely lovely to be here. In cricketing terms, it's my hat trick. I was at the first, second, and third editions of the Pakistan Disputes Week, and I'm delighted to be here again. I also wanted to thank the organizers for inviting me, but also perhaps to borrow from Lord Hewitt's famous dictum that justice must not only be done, but also must be seen to be done. And I'm afraid I'm going to stretch that a bit by saying it's so delightful to see so many judges here from all the courts in Pakistan. It's lovely to see justice here at this conference. It's very, very reassuring. So before I launch on to the topic, I also have a disclaimer, and perhaps I can't put it as elegantly as my co-panelist judge has done. In addition to serving as an arbitrator and as a barrister at 20 Essex, I have also taken on a new role where I'm an external judge of the World Bank Sanctions Board, which means that whatever I say today does not reflect on the title I hold at the World Bank, and I am speaking as an independent practitioner. So with that, I shall get to the very interesting topic that our chair has raised for me. Now, ICC arbitration has been around, but in a sense, international arbitration has many, many different institutions and has had an interesting history in Pakistan. I think some of us are old enough in the room to remember the famous Hubco case of the 1990s and how arbitration has evolved over the last few decades, not just in Pakistan, but across the world. And every time I speak to newer practitioners now, it's very hard for them to understand that there was a time when courts were very concerned and perhaps even a little jealous about international arbitration. Those days are long gone, and as my co-panelist said, it really is key to enforce the bargain that the parties have agreed to, provided it is a valid bargain. And that's incredibly important for not just international arbitration, but rule of law, and as my other co-panelist, Mr. Sufi, said, for trade and investment, because that's the key pillar that drives investment and trade, particularly when it crosses borders. I work in so many jurisdictions and so many courts, and often people ask me, which court, which jurisdiction? And I always say, depends whose court you're in. You always have jurisdiction over your own court, and that's where you reign supreme. But we shouldn't forget that those parties, especially if they have cross-border trade and investment, will also have other courts. And it's so important to be mindful of other jurisdictions in making your decisions. And this is where I come then wholeheartedly to the question that the chair has raised for me. How has Pakistan fared? What do we mean by state entities and states' experiences with international arbitration? Pakistan signed the ICSID Convention very early on. It has been quite open to signing a number of bilateral investment treaties. In the 80s and 90s, state entities and the state itself was quite happy with agreeing to international arbitration clauses, be it ICC, be it ICSID, even LCIA. So the state has been quite open. And in fact, I would say in the early years, very open also to foreign law. So bear in mind that the arbitration clause has different pieces to it. As a mechanism, you have the governing law of the contract, which can be separate from the law of the arbitration clause. And often the compromise that states make is we will have our national law, but we're happy to agree a foreign law of arbitration by, for example, designating a foreign seat. So the compromise you found was Pakistani law is the governing law of the contract, but the seat could be ICC London or ICC Paris or just LCIA. With ICSID, of course, it's a bit more complicated because in reality, ICSID is a self-contained system. So what you see in Pakistani sort of contracts is you either see Pakistan as the governing law and you see a foreign seat, or you also see what has become, I think, more increasingly common is you see both the seat being in Pakistan, but with an ICC Pakistan sort of provision, but the law is also Pakistan. Those contracts mean that the government has bargaining or negotiating power, typically when it's hiring someone. It's slightly different when you're trading as equal parties and you're trying to find a compromise law. So that is where the compromise typically happens in favor of a law. English law, since it's my jurisdiction, is often a compromise law, which keeps us busy. The problem is when you're dealing with a civil law jurisdiction like China, and I'm here encroaching on my co-panelist's sort of domain, to find that compromise. I think, just to wrap up the question you put to me, it's very important for states to understand the arbitration provision and the obligations it imposes. I recently represented a Central Asian state against a government contractor, another civil law country. Both were civil law countries. And it amazed me that the contract was governed by English law, the seat was London, it was an LCI arbitration, and civil law was completely at odds with the state entity's own constitution. I mean, the civil law was there, but it was completely at odds with the English law that was governing it. And it came as a real rude shock to them to find out that they'd breached everything. So the message I really have here is, please, when you enter into arbitration agreements, that is the time to understand the obligations you're taking on and to ensure that you're not in breach, so no surprises come in the arbitration proceedings later on. Thank you so much for that question. I just wanted to put an overriding principle. Of course, it's the tribunal's duty to render an enforceable arbitration award. And that is precisely why parties enter into an arbitration proceeding in the first place. I mean, it's not just fun and games for the lawyers. I mean, the parties want an enforceable award at the end of it. And I think serving as arbitrator, I'm extremely mindful that it's not just the substance of the final award, but also the process that leads to the award. So by the time you've delivered an award, if certain procedural safeguards have been missed along the way, then it's a little too late. And I think when you are dealing with cross-border sort of arbitrations, it's very important to remember that it's not just the seat of the arbitration, but also where the arbitration award might be enforced. So perhaps the best way to illustrate it is a case that I was serving as on an arbitral panel. It was an institution that didn't have that much experience with the respondent's home jurisdiction. And we had a non-participating respondent. And under this institution's rules, email service was perfectly normal. And, but given the fact that I knew the jurisdiction, I realized that we had to make sure that the respondent was served by courier copies, in multiple, preferably with proofs provided to the arbitral tribunal at every stage, because it was so important that the respondent couldn't turn up resisting the arbitration award we had delivered, saying, I never received that email, and in any event, in my court, service by email is not recognized. So, answering your question, I gave a very small example, but it's these small little things sometimes where procedural fairness is concerned that you often trip. So, it's very important for the tribunal to safeguard procedural and substantive rules throughout the procedure, right from the time of appointment, not just at the time of the award. I think my tip is going to be very practical, and I think it's the full life cycle of the arbitration process. So when you're negotiating your contracts, to understand and anticipate a dispute might be in the offing. I mean, as a disputes lawyer, I tend to be fairly pessimistic because I see things falling apart all the time. But transactional lawyers tend to be more optimistic. So when they actually are negotiating the contract, particularly the arbitration provisions, it's very important to be mindful that there might be a dispute later on. And if you're agreeing a seat or a law later on, then you must understand the obligations of that law. And English law, if you are going to choose it, it's very important to make sure that you get English counsel's advice on enforceability, because English law has changed tremendously over the years. So that's my first tip. The second big tip is try not to breach the contract. I know it sounds like a very silly thing to say, but please, if you are taking on obligations, be aware that those obligations will eventually be before a tribunal or a court, and therefore you should do whatever you can to make sure that you're not doing anything wrong and behave in a manner that's appropriately, because the correspondence that you write today will be before a judge later on, and they won't be very happy with what you say if it is not appropriately worded. And finally, if you're using AI, please be very careful. It is not a defense to say, I didn't write that email, Claude GBT did it. Right? So it's very, very important when you're not speaking English as a native language and you are relying on technology, because each comma, each word matters in an international arbitration.